Good morning, everyone. Welcome to the Joint Standing Committee on the Judiciary. This morning, we have a number of work sessions that we'll take up. We will start with committee introductions, and I'm just going to call on committee members and let them introduce themselves. We'll start with you, Representative Cardone.
Hi, I'm Barbara Cardone. I represent House District 127, part of Bangor.
Thank you. And Representative Babbage.
Good morning. My name is Christopher Babbage. I represent House District 8, which is most of the town of Kennebunk.
Thank you. And Representative McCrate.
Good morning. I'm Jay McCrate, representing Harpswell, West Bath, and Northeast Brunswick in the House.
Thank you. Representative Reckitt.
Yes, I'm Representative Reckitt, and I represent District 31, the ocean end of South Portland.
You, Representative Moriarty.
Good morning, all, and happy Memorial Day weekend. I'm Steve Moriarty from House District 45, which is Cumberland and part of Gray.
Thank you, Representative Sheehan.
Good morning, everyone. My name is Erin Sheehan, and I represent Biddeford's House District 12.
Thank you, and Senator Sanborn.
Thanks, Senator Kearney. I'm Heather Sanborn. I represent Senate District 28, which is half of Portland and half of Westbrook.
Thank you. And I'm Ann Carney. I represent Senate District 29, which includes South Portland, Cape Elizabeth, and a little bit of Scarborough. Before we take up our work sessions today, I just want to let everyone know that committee members this time of year are pulled in a lot of different directions. All of the committees are trying to wrap up their work by the end of the day today. And so we may be joined by other committee members as the morning proceeds. I will not be able to participate in the work sessions this morning. And so I'm going to hand the virtual gavel over to Senator Sanborn, who will chair this morning's work sessions. Thank you, Senator Sanborn.
Thank you, Senator Kearney, and enjoy your family, and happy Memorial Day weekend.
Thank you.
All right. Everyone should bear with me. I've chaired a lot of committee meetings, but not in the Judiciary Committee. So I will do my best to follow Senator Kearney's culture and demeanor as we proceed through our meeting today. The first work session that I will open is on LD 1606, an act to expand tenant representation on boards of directors of nonprofit housing organizations. And we'll bring, let me see if Representative Grahowski is here. She is, so I'll bring her in, as is the custom in the Judiciary Committee. And while she is joining us, I think I'll ask Peggy to give us the rundown on the bill.
Great, thank you, and welcome to the gavel. So LD 1606 is an act to expand tenant representation on boards of directors of nonprofit housing organizations. This bill amends the Nonprofit Corporation Act to include a new section that would require when a nonprofit corporation organized under this title, so it's a state, it's organized in this state, incorporated in this state as a nonprofit corporation that has rental units in a multi-unit residential building. It must include on its board of directors a current tenant of the building. It doesn't cover emergency temporary shelters, and the sponsor actually has a proposed amendment that she included in her testimony that would clarify it that a corporation that has an ownership interest in any multifamily rental housing has to include at least at a minimum of one current tenant of the housing, and goes on to explain if you can't find a tenant to participate, it has to advertise the position, and the name and contact of the tenant member of the board of directors has to be available in a public location in each building for the housing that's owned by that corporation. And again, it doesn't apply to entities that apply. It doesn't apply to housing that are emergency shelters or short-term transitional housing. I'd be happy to answer any questions.
Thank you. Are there any questions from the committee with regard to LD 1606? All right, I'm not seeing any questions, so I would entertain a motion. Representative Babbage.
I move to pass as amended.
All right, is there a second? Seconded by Representative McCray. Is there any discussion on the motion? All right, seeing none, we're ready for the vote.
Thank you, Madam Chair. Senator Carney, Senator Sanborn,
Yes, sorry, I forgot I was first. Go ahead.
Senator Sanborn votes yes. Senator Keim, Representative Harnett, Representative Babbage,
Yes.
Representative Babbage votes yes. Representative McCray,
Yes.
Representative McCray votes yes. Representative Cardone,
Yes.
Representative Cardone votes yes. Representative Galgay-Reckett,
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty,
Yes.
Representative Moriarty votes yes. Representative Sheehan,
Yes.
Representative Sheehan votes yes. Representative Hagan, Representative Poirier, Representative Evangelos.
Yes.
My apologies. Representative Evangelos votes yes. Representative Newell. I will recall the absentees. Senator Carney. Senator Carney is absent. Senator Keim. Senator Keim is absent. Representative Harnett. Representative Harnett is absent. Representative Hagan. Representative Hagan is absent. Representative Poirier. Representative Poirier is absent. Representative Newell. Representative Newell is absent. Madam Chair, I have 8 members voting in the affirmative, 0 in the negative, and 6 members are absent.
Thank you very much. And Representative Evangelos, it's nice to see you this morning. Would you like to introduce yourself?
Sure. Thank you, Senator Sanborn. Jeffrey Evangelos, House District 91. I reside in Friendship.
Welcome. Okay, so moving along, the next bill that we will pick up is LD 1612, an act to facilitate children's testimony in certain sex crimes. Oh, I meant to thank Representative Grochowski, so I thank her as she heads back through the wormhole. Okay, so next 1612, and I'll have Peggy do her analysis.
So thank you. 1612 is an act to facilitate children's testimony in certain sex crime cases. And what this bill does, it sets up a statutory process for a child to testify outside the presence of the defendant. It's actually fairly specific about what the requirements are. And there has to be a motion to allow this because it's almost like allowing hearsay in. So it's prior to trial. It allows for the recording of the testimony, I believe, and the direct testimony that the child can testify outside the presence of the defendant if the testimony is conducted by way of a two-way closed circuit television or other audiovisual electronic means. The testimony must occur at a recognized children's advocacy center with only the victim or witness advocate present in the room in which the child is testifying, so nobody else is allowed in the room. Live cross-examination of the child must be provided to the defendant's attorney after the child's direct testimony. So it's live cross-examination, so it's real time, but the attorney is not in the room with the child. In fact, neither of the prosecutor and the defense attorney are not in the room with the child. The exception is when the defendant doesn't have an attorney, or if the positive identification of the defendant is required. So in that case, there would have to be a face-to-face testimony by the child. But it's following up on the U.S. Supreme Court case that from several years ago, Maryland versus Craig, where the U.S. Supreme Court said, yes, the confrontation clause of the Constitution is very important, but as long as the court makes sure there's reliability and trustworthiness of the testimony, and the state can, in the prosecution, can identify the specific necessity for the child to be testifying outside of the actual presence of the defendant. And there's these indicia of trustworthiness and reliability that this can happen and it's not a violation of the confrontation clause. So we do have a law on the books about this, but I'm not sure how often it's used, and it's pretty broad. And I think that this would give very specific instructions on how to carry out this testimony outside of the actual presence of the defendant. Most states have some version of this, and actually after the Maryland versus Craig decision, the federal government adopted a similar statute, not quite with these same requirements, but basically the same idea about a two-way closed circuit television to ensure that the children are not re-traumatized by the testimony, and but also to make sure that the defendant has the ability to make sure the child is questioned by his or her attorney. I don't know if that's helpful. If you have questions, let me know. And I see that the sponsor is here as well.
Are there questions for Peggy? Representative Moriarty.
Thank you, Madam Chair. Peggy, I assume, but I want to ask you directly, that the phrase direct testimony includes cross-examination as well.
I don't think that's intended, which is why paragraph C says cross-examination of the child must be provided to the defendant's attorney after the child's direct testimony.
Well, that was going to be my next question. I don't quite understand C, because if the testimony is taking place live, why is it necessary to say that it must be provided to the defense attorney? My thought was that the defense attorney would cross-examine live while the child is at a different location. So
when you say live, do you mean in person in the same room?
No. I just mean in real time.
Right. I think that's intended. There was a case in Maine where it was recorded prior to trial. And the court accepted it because it went through all the reasons of why it was trustworthy, why it was reliable testimony, why it was necessary to do so in the first place. And I don't think that this prohibits the recording and then the playing of the recording in court. I also don't think it, I think it would allow it to be happening during the court proceeding itself. But in any case, I think it means it all has to be kind of contemporaneous. I think that's what the live cross-examination of the child means.
Well, again, how do you provide live cross-examination to the defense attorney who was the person who's conducting the cross-examination?
I understand what you're saying. I think the wording might be a little bit, yeah, okay. I understand what you're saying. I was reading it as the defendant's attorney shall be permitted must be permitted to cross-examine the child. Right,
Yeah, that's what I think. the intent-
contemporaneously, whatever,
Oh.
right, no, good point.
Peggy, I'm going to suggest that we wordsmith C to say the opportunity for live cross-examination.
Yep.
And Representative Moriarty, does that satisfy your concern?
I think so. I think it eliminates a real
Okay.
ambiguity. I do have a final question for Peggy, if I may, at this
Go
point.
ahead.
And this deals with section C. I understand that if a positive identification is required, that the child needs to come into the courtroom, and the DA needs to say, is the person you've been speaking about present in the courtroom? Can you point him out? And that satisfies the confrontation clause. But what is the point of the reference to the defendant being self-represented? What difference does that make?
I don't know if the case law says that you can't do this if the defendant, you can't do the out of the presence if the defendant is serving as his or her own attorney, because that might just be a very difficult hurdle for somebody who is pro se to navigate this.
But they're asking the same questions, it's just that
Right.
the person is, and if they can see the person and they listen to the live responses, I'm perplexed by this.
Right, and perhaps the sponsor can answer, or some of the advocates for this bill. I do not have an answer for that.
I'd be happy to hear from anybody who may know.
Representative McDowell, go ahead.
Unfortunately, I do not have an answer to that either. I'm hoping that there may be somebody in the waiting room who does.
Okay. Representative Evangelos.
Thank you, Madam Chair. I just wanted to respond to something Representative Moriarty just stated. Having somebody come into a courtroom and point at you does not satisfy the confrontation clause. Confrontation clause allows you the rights to confront your accuser, not the right for somebody to come into a courtroom and point at you. That's a very important distinction here. Thank you.
Okay. I'll take a stab at this. I think Peggy is onto the pro se piece, which is to say that the point here is that the child is going to be cross-examined remotely by an attorney in this procedure, not cross-examined remotely by the defendant himself. So if we're in a situation where the cross-examination is going to happen by the defendant himself, this whole procedure is a bit elaborate because the person on the other end of the computer or the TV screen is the actual defendant that we're trying to shield the child from. So the whole procedure kind of falls apart in that situation because the questioning has to be done by the individual who is actually the one we're not wanting to have the child need to see in person.
Right, but why, I don't understand why the video link process cannot be followed if the defendant is self-represented.
Because the video link would still have the person on the other end that was the one we were shielding the child from, so the shielding doesn't occur.
Well,
it's just you're not physically in the same room, but you have to look at the person on the screen and answer their questions in a direct way. And perhaps there's just not any benefit, as well as there being a hurdle to the pro se defendant to have to navigate the technology. So it starts to lose the point of it, because the point is to provide the child with the opportunity not to be in the room with the defendant, and that's not possible in a situation where the defendant doesn't have an attorney to do questioning for him or her. Representative Babbage has his hand up. Perhaps he can help.
Hit the wrong one. Thank you very much, Madam Chair. I guess my question would be to Peggy here. but I'm thinking, I guess what I'm questioning with regard to number 3, it does make sense to me if the judge in the actual courtroom has control over whether the pro se defendant is able to approach the witness, and control the setting. I'm wondering, what is the role of the judge in the remote? And of course, if the per se defendant is right up close, like I am right now, in a even in a remote setting, that could be less controlled, perhaps, than. So I don't. Can you clarify for me the role of the judge in the bill as presented for the testimony of the victim?
Well, in some cases, it's actually recorded testimony that is then played for the court. It could be a jury trial. So I'm not sure that the judge is actually where the judge would be in those situations, and it might be more like a deposition in which the judge isn't even a participant. If it's something that's happening during the court proceeding itself, then the judge would be there, and that is possible, and that does happen in some states.
Thank you, because my thinking was that if it is similar to a deposition, then the court could actually have the judge be more of a protector of the victim than the remote proceeding would be, and that's why number 3 is in the bill. Thank you.
Representative Moriarty.
Thank you, Madam Chair. It's very well established in the case law that a self-represented defendant must abide by the same rules as an attorney, and that no special accommodations can be made for a self-represented individual. That's been the case for decades. So as to Representative Babbage's question regarding the role of the judge, it is basically identical to what it would be if the defendant had an actual attorney. The judge can determine that a line of questioning is inappropriate, argumentative. I don't think that there ought to be an ability to lean into the camera or tamper with the technology in any way. But I think the judge has basically the same control as in a conventional trial setting. And the self-represented defendant has no, let me strike that and start again. It's well established that you don't cut slack for a self-represented defendant in a criminal trial.
So Representative Moriarty, I think the thing you're missing is that the whole bill is about testifying outside the presence of a defendant, not just the physical presence, but the presence at all of a defendant. And there's no way to do that if the defendant himself is the attorney. So the whole concept of this bill is inapplicable in a situation where you cannot be outside the presence of the defendant because there's no one to represent the defendant if you are outside the presence of the defendant. So the purpose of the entire section of law is defeated, and the purpose of the section of law is to protect the child. And there's just no way to do it and not offend the Constitution if the defendant does not have an attorney to do the questioning. So the section of the bill is moot, or the section of the law is moot at that point. It's impossible to accomplish the goal of this bill of protecting children if the defendant has no attorney.
I'm not sure that I follow, Madam Chair. I visualize a situation in which the self-represented defendant stands up when his turn comes for cross-examination, looks at the camera, looks at and presents his question. There's a screen there. He can see the victim and see her respond, listen to her respond in real time. and they conduct an examination back and forth in the same fashion they would in the courtroom, except that the witness who would otherwise be on the stand may be in a different room of the courthouse. I don't.
The witness would have to be in a recognized children's advocacy center, but the point being, Representative Moriarty, I'm afraid that what we're trying to do is allow the testimony to happen without the child encountering the defendant at all. And in your scenario, the child is encountering the voice and the visage. It's two-way audio and visual. So the child is being questioned directly by the defendant. And that has to happen if the defendant is pro se. But the whole point of this elaborate two-way camera situation
Yes.
is defeated. So we have it happen in the courtroom instead, where the judge can control the proceedings.
Respectfully, Section 1 says that the court may allow to test the young victim to testify outside of the presence. It doesn't say that the victim must be concealed from the defendant or that the defendant cannot observe the victim.
The defendant can observe the victim, but the victim has to be allowed to testify outside the presence of the defendant. And outside the presence just doesn't mean not in the same room. It means not having to see the person.
I think we disagree on that point.
Okay, Representative Babbage.
Thank you. My question is, when we talk about in number 1, first paragraph, outside the presence of the defendant pursuant to this section in a criminal proceeding. In the criminal proceeding, does that mean the trial itself, or is this bill permissive of, like the motion, the actual interchange being pre-trial? Does this bill require that this be simulcast, or is it permissive that the testimony be given pre-trial and the cross-examination pre-trial, and then entered into the record as part of the proceedings at trial?
I think Peggy answered that earlier and can answer it again.
Right. I think this is enabling legislation in a way, in that it allows either one of those scenarios to work. So they can do it actually within part of the trial itself, or they could do recorded testimony and make sure that everything's set up so that the defendant is involved in that, not in the presence of the child, but the defendant's attorney has the ability to question. All of that is recorded, and that can then be played in the trial. So that if you have all this, then that allows that to go forward as admissible evidence in the trial. If you don't have this, all these out of court statements aren't usually admissible. They are hearsay. So this is doing two things. It's trying to protect the confrontation clause rights of the defendant. At the same time, it's allowing the admission of out of court statements to be accepted. They have to be reliable, they have to be trustworthy. This lays out the process to try to ensure that.
Thank you. But the understanding here is that that prescription is not prescribed in the bill. It is determined by the judge in the process.
That's my understanding. Yeah.
Representative Sheehan, you had your hand up. Did you have a question?
I don't think so. I think we just got to it through Representative Babbage's question.
Okay. Is there further discussion on the bill? All right, seeing none, I'd love to have a motion. Representative Evangelos.
I thought we were just discussing it with Peggy. I do have some further discussion.
Okay, go ahead.
Well, certainly the motives of the bill's sponsor are noble, and nobody can question that. but I am a documentary historian. I followed these cases through the 80s and 90s. The McMartin preschool case, Fells Acres daycare. There were literally dozens and dozens of false accusations, charges, and convictions due to malicious prosecutors and counselors who convinced children that they had been damaged when they hadn't been. In some of these cases, the exonerations came 20 years later. Just Google McMartin preschool case in California. In 1692, children were fingering women as witches, and they were executed. The ACLU testified against this bill, and so did Walter McKee, for these very reasons. So I'll allow somebody else to make a motion. But I do want you to know that the Washington Post had an article, 2015, how the daycare child abuse hysteria resulted in a new Salem witch hunt era. And in a lot of these cases, the accused was not able to face the accuser. And some of the cases, after they were resolved, revolved around prosecution of certain counselors for convincing these poor kids that they had been abused when they hadn't. I'll let you do your own research. All you have to do is Google the daycare center false accusation scandals. I mean, the cases are too numerous to cite. All resulted in eventual exonerations. All resulted in the destruction of families and lives for people who had done nothing. So I'm not going to be supporting the bill. I think these constitutional shortcuts don't work. They lead to trouble. And I know these are difficult cases, but if you're innocent and falsely accused, you've got to have your rights. And we have to remember that. This is not ancient history from 1692. It's just an example. But this Washington Post article was recent. And I'm on one site right here where they've listed 25 cases where the defendants were all found guilty because of this process and later on exonerated. This is a slippery slope, folks, and I hope you think about it carefully before you vote.
Thank you, Representative Evangelist. Are there further comments on the bill? I will make one, which is just to say that I think that the implication that all of the cases, the adults were exonerated later is I know what Representative Evangelist was getting at, but in fact, we know that it's far more common for kids not to lie about this sort of thing and not to have been influenced or coerced, but instead to be terrified to come forward, whether it's gymnastics, whether it is Little League coaches, whether it's Boy Scouts, whether it's the Catholic Church. We have had issues in this committee with very really egregious cases against, offenses against kids. And as a parent, I can't imagine having to decide whether to go forward with the case on behalf of my, on behalf of my injured child, or to protect them from further trauma by ensuring that they didn't have to go into the courtroom. That's not a choice that parents should have to encounter. So I will be supporting this bill. And I think it is constitutional. I think the Supreme Court has told us it's constitutional. And I think in light of the technology that we have available, which we're using right now, frankly, we can have the indicia of reliability and the ability for the defense attorney to use all the normal tactics to probe whether the child is trustworthy and whether the testimony is reliable. So I think that while I understand your concerns, Representative Evangelos, I think that on balance, and this is a balancing test, and on balance, the public interest here is very much in favor of protecting young children from having to be re-traumatized in our justice proceedings. Representative Evangelos.
Thank you, Madam Chair. I respectfully disagree. I've documented, I can document right now, I won't put you through it, but 20 or 25 cases, and you haven't documented one. These constitutional shortcuts don't work, and this isn't how the Constitution works. You know, the worst offender, our worst enemy, is still entitled to the due process provisions of the Sixth Amendment. It's an uncomfortable situation, but it's there to protect all of us from, you know, malicious prosecutions, from false witness, from bad faith. And I'm not willing to suspend that. And, you know, either was Walter McKee, and I consider him Maine's finest lawyer, extremely intelligent, and he would not speak on a matter like this lightly. I hope we can respect that my concerns around this bill are well-founded. They're documented in history, and we simply can't set up an inquisition system, which is really what this leads to, and be carving out these exclusions of what have always been clearly constitutional rights. So respect your opinion, don't agree. The history of these cases is on my side. Look what happened to these people they destroyed. And if you're willing to sacrifice these kind of innocent people to create this objective, that's fine. I'm not.
Okay, thank you, Representative Evangelos. Are there any further comments on the bill?
Yes, I'm afraid.
Go ahead, Representative Babbage.
Oh, I'm sorry, I was on mic there.
Yes, you were.
Thank you, Madam Chair. I take Representative Evangelos's comments to heart. I mean, this has always been a difficult question. It's not the first time something like this has been before us. I'm bothered by two parts of the bill, which I'm willing to correct. It doesn't meet anybody's standard, but to get on board perhaps. But what I am going to support is a live-only testimony that would be closed circuit. And I do object to Part B, where the testimony must occur at a recognized children's advocacy center with a victim or witness advocate present. Obviously, that's very considerate of the child, but I would want it to be at a neutral location of the court, accompanied only by court officers to assure that any kind of undue influence would be minimized, because I think there is value to being in the courtroom. If being in a neutral testimony with neutral court officers is not palatable for the child, then I think this option should be declined by the defense attorney, by the prosecution rather. So I want the option to be there if it would be an advantage to the victim, but I'm not willing for it to be pre-recorded, nor am I willing for it to be at a site that may give advantage to one side over another. So that's where I am on this. Thank you.
Okay, I'm hoping to hear from some other members of the committee. I think I appreciate that. And Representative Evangelos, I see your hand up and I'll get to you, but I want to I want to get some more input from other members of the committee, given that we've now got 3 potential outcomes here that have been proposed. Representative Moriarty.
Thank you, Madam Chair. In response to my colleague's questions of a moment ago, I just want to point out that this procedure is not available as a matter of right, but only upon motion to the court. And the court, i.e. the judge, is going to listen to the arguments from the parties and will be fully informed upon the technological arrangements and the location at which the child will testify and any arguments why it ought to be in a so-called neutral location as opposed to an advocacy center. And only then, after full adversarial discussion, will the judge rule as to whether or not this happens at all. So I think there are really many built-in safeguards at the outset before the first word of testimony is taken. So I don't share those same concerns. Thank you.
Representative Evangelos.
Just very briefly, I did want to respond to Representative Babbage's comment regarding providing an advantage to the victim. Folks, it's not our court's job to be setting up an advantage to anybody in a judicial proceeding. The judicial proceeding is set up to be fair and impartial. And upon conviction, they're held accountable for it. But we can't be setting up a system that, you know, with a preconceived notion that the court is setting up an advantage for anybody. I hope you all understand that. Thank you.
Are there further comments on the bill? Okay. So I'll comment on Representative Babbage's proposed amendment that I believe that it's very important to have folks who understand the psychological needs of children, who are trained to understand that and licensed to understand that. This doesn't permit parents to be in the room, and it only permits a witness advocate, or it only permits this witness advocate. So I think that the safeguards that are here are a good balance that is established as the scenario in other states, and that is appropriate under Supreme Court precedent. And I think that protecting kids by making them go to a place that's not designed for children, and that making them sit in a room with a stranger who knows nothing about children, but knows about, I don't know, being a security officer in a court, is not accomplishing the goals that are set forth in this statute. And again, I just go back to thinking about my own child, and just, you know, he's 17 now, so he would not qualify for this if he had become a victim of a crime. But thinking about very young children and what we need to do as a justice system to ensure that justice can be served without the justice system itself becoming an abuser of our children. And I think this bill really drives that narrow balance. So I won't be voting with Representative Babbage on the narrowing of it, because I think it actually could be far more harmful to children to put them in that situation where they can't have their parents in the room, and they also can't have a trained victim advocate who knows about children. Representative Moriarty.
Madam Chair, I will move ought to pass with the understanding that Peggy will revise the language of section 2C and that we would then review that in language review as soon as we can.
So ought to pass as amended then, Representative Moriarty?
Yes, yeah, that's a good point. Yes, yes.
Okay, is there a second for Representative Moriarty's motion? Seconded by Representative Cardone. Is there further discussion on the motion? Representative Evangelos, go ahead.
Thank you, Madam Chair. I would like to hear from Mr. McKee, please.
Okay. We'll bring in Mr. McKee.
Good morning.
Good morning, Mr. McKee. Representative Evangelos, do you have a specific question for Mr. McKee?
How long have you been on, Walter?
Just from the past 5 minutes. So I'm a little late to the party, but I caught a little bit of the last language.
Well, I'll frame a question for you. I gave a historical review of the daycare scandal period, about 25 cases across the country where malicious prosecutions occurred. People did serious jail time. Defendants were not allowed the right to confront accusers. The McMartin preschool case, Fells Acre, there's dozens of them. And it goes all the way back to 1692 when children were used as false accusers against women in Salem. So I'm raising those objections to this process, and I think you're caught up on the rest of it. I just want to hear your concerns about this process because I know I share them, and I know how deeply everyone on this panel respects you. I thought it would help for them to hear your voice.
Sure. Just by way of just some just general information, of course, as probably everybody knows, this bill or something like it has come up for quite a few years now and has not passed for a variety of different reasons, and I won't go through that history. I think one of the standing concerns has been the setup has never been in a way that people felt comfortable going forward. I will tell you that I've dealt with many prosecutors, including one who I had cases with for many, many years, very esteemed prosecutor in sex offense crimes, who actually said if this is a process that was going to happen, that they were not going to employ it. They were going to actually decide not to do it because of concerns about really how this is actually perceived by a jury. And so that's a choice that a prosecutor can make. But I just wanted to comment on the two last pieces that I heard in terms of the process. First of all, the bill says upon motion by the state with a reasonable notice, a court shall allow a child who's 14 years of age or younger to testify. So there's actually no leeway for the court at all. The court must do so upon motion. Now, there are certain standards that have to be made, but as the bill is written right now, the court has actually no discretion. The court has to grant it. And that's why the shall language is in there. And shall means shall in our language, and it's very important as opposed to may or in the court's discretion and so on. So that's issue number one. Issue number two is one that concerns us, and we all know this from doing the Zoom proceedings now, which is that there's somebody else in the room with the child. And there are certainly some reasons for that, and I understand, I respect those. But the one thing that I'm always concerned about, and we're always concerned about, is the presence of somebody else in the room that might have either direct or even indirect some influence on the child. And I'm not saying they're telling the child what to say necessarily, but these are people that are outside the view of anyone. And I know this a lot, of course, from my civil practice and depositions where you don't know who's behind the person. Sometimes you'll see a person's eyes darting over, looking at someone else. And it always is a cause for concern because we don't see what may be indirect cues, if you will, or even direct cues from someone to nod their head slightly or to shake it a little bit in terms of what the answer should be. And I think that's kind of really the heart of the confrontation piece, is that if we have it all out there for everybody to see in 360-degree view, we know what it is. And so I think that's always been the issue, and it's not going to be corrected by our modern technology and our ability to do things in a better way now than we used to be. It's still the same old problem. So I just want to make comments about those two, and I really appreciate the opportunity to weigh in. I'm sorry I was a little late getting here. I was in court and headed into a mediation soon.
Thank you, Mr. McKee. Are there additional questions for Mr. McKee? Representative Cardone.
Thank you. Mr. McKee, if the wording of shall to may, a court may order, does that, if we change that wording, would that eliminate one of your concerns? I realize it still gives you the issue of the who else is in the room, but giving the court some discretion, would that give the defense attorneys some larger level of comfort with this?
Yeah, I think it gives everybody better comfort, even the judges, because that shall is something the judges don't want to be bound by. So certainly on part one, if you will, of course, I don't think it should be a shall at all.
Okay, thank you.
Are there any additional questions for Mr. McKee, Representative Babich?
Thank you very much, Madam Chair. Mr. McKee, could you help me with degrees of concern regarding if this were to be implemented? Is it different if it's done in depositional form to be admitted as evidence later, both direct and cross, versus live? Could you help me to understand that a little more?
Yeah, that's a great question. Let's just say you do it before or some other, the day before you take the testimony. That sometimes you can do criminal depositions in unique circumstances. And the peril of that is you just don't know what's going to happen when it comes to trial. And you've pretty much got one shot. So you take the testimony, you think, okay, great, we've got it in the can, so to speak. You go to trial and everything is completely turned around. You might have some other witness talk about an inconsistent statement. Geez, I can't go back and do that again. I already had the testimony. And when it takes it out of order like that, and you don't have the ability to recall them and actually, kind of part of that dynamic process that we deal with in trials all the time. Lawyers on this panel, I'm sure Representative Cardone knows as well. When trial starts, everything often changes as much as you would like it to be like that. And so I think that's a very a concern that we would have as far as doing it that way. And I would just say that, this has been happening for a long period of time. And so we've all tried these cases and they're not great cases. As a defense lawyer, the last thing you want to do is be cross-examining a young person. That's very difficult. But I think that it has happened. And that oftentimes with good prosecutors, and I think the prosecutors that handle these cases know how to deal with them. Very considerate judges that understand and appreciate this is not going to be like a usual cross-examination, that it happens. It's not great, but none of these cases are great. But certainly for the accused, that opportunity to actually be there and be part of that process and have it happen in the course of a trial is super important. And that's why we were opposed to it.
Okay. I'm going to put Representative Babich's hand down because I have the power to do that, being chair today. All right. Are there any additional questions for Mr. McKee? All right. So I'm going to, Representative Moriarty, go ahead.
Madam Chair, as the person who made the motion to pass, I would revise my motion to delete the word shall in section 1 and substitute it with the word may.
Representative Cardone, is that okay with you? Yes, okay. That sounds fine. Okay, so that's the motion on the table. I do want to bring in DA Maloney, Megan Maloney, so I'm going to do that now. Good morning. So there were some questions raised earlier in our discussion about the reliability of children. And I guess my question is whether using this procedure and then a skilled defense attorney who has the opportunity for a live cross-examination, can we approximate the same probing of the reliability of a child under these circumstances, in your view, as we would be able to do in a courtroom?
That's a great question. And first I want to say I'm glad to hear the amendment, because I do agree with the amendment that was just made. With these cases, I look at State versus Twist, which is the law court case that did allow for children's testimony. And in order to make sure that there was that reliability, because I hear what Representative Evangelos is saying, that it is critically important that each witness be tested and that we have that assurance of reliability, that what the court did in State versus Twist is it did allow for the child to testify, and I'm reading right from the case here, in such a manner that the defendant would not be able to view the child. I mean, the defendant would be able to view the child, but the child would not be able to view the defendant. So that would give the defendants and the defendant's attorney would have, quote, the right to confront and cross-examine the state's witness on behalf of the defendant. So what they did in State versus Twist is it was a deposition type setting. It was outside the court, and they had videotape testimony of the child. That would, of course, be done now at a child advocacy center. We didn't have those at the time of State versus Twist. The defense attorney was present, and the child presented both direct testimony and cross-examination testimony. The defendant was present, but as I said before, the child could not see the defendant. And the defendant was, with a one-way hookup, could view the videotape simultaneously, and because he was behind a mirror, and the proceedings were stopped for him to talk to his attorney, and they were in constant communication. So there were a number of safeguards put in place, and that's really why it is so important that the court may, so that the court can put in place all those safeguards. You do need to have defense counsel with the ability to cross-examine the child. You do need to have the defendant be able to see what's happening and provide counsel and advice to his or her attorney in real time as it's happening. And so the court really laid out those requirements in State versus Twist. And what I think could be helpful here is memorializing those requirements in statute so that we have that ability to point to the statute, but always giving the discretion to the court.
So, Megan Maloney, I think what I'm hearing you say is that one of the elements of State versus Twist that's missing from the draft in front of us is the reference to the defendant being able to observe the questioning in real time, but while the child is shielded from the defendant. And I think we could add that as an additional element under 2, because I think it's actually what was intended as we
yes,
proceed.
I do think that's important. I think that the defendant being able to communicate with his defense attorney while the questioning is happening, the court told us in State versus Twist that that's very important, and the defense attorney being able to provide cross-examination, very important.
Yep, and that's protected in the language of the bill already.
Yes.
Okay. So Representative Moriarty, I'll go to you and ask if you'd want to further amend your amendment to include another provision that allows for the defendant to observe in real time and communicate with his defense counsel.
Yes, you've stated it well, and that is, I would include that within my motion to ought to pass as amended.
Okay, and Representative Cardone. Okay. All right, is there further discussion? All right, I don't see any. I'm going to thank you very much for joining us, Megan Maloney, and I'm going to send you back.
Happy to.
Okay. Is there further discussion of the motion that we have pending? Okay, if the members of the committee who can hear me could turn on their video so that we can determine if we have a quorum. Wonderful. All right, so we do have a quorum. And so Supi, I think we're ready for the question.
Thank you, Madam Chair. Senator Carney. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Kine. Representative Harnett. Representative Babbage.
No.
Representative Babbage votes no. Representative McCright. I need to see you, please.
I don't think she's there. I think that's.
I'm sorry. I thought I heard.
Yeah.
My apologies. Representative Cardone.
Yes.
Representative Cardone votes yes. Representative Galgay-Reckitt.
Yes.
Representative Galgay-Reckitt votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Poirier. Representative Evangelos.
No.
Representative Evangelos votes no. Representative Newell. I will recall the absentees. Senator Carney. Senator Carney is absent. Senator Kime. Senator Kime is absent. Representative Harnett. Representative Harnett is absent. Representative McCright. Representative McCright is absent. Representative Hagan. Representative Hagan is absent. Representative Poirier. Representative Poirier is absent. Representative Newell. Representative Newell is absent. Madam Chair, I have 5 members voting in the affirmative, 2 members in the negative, and 7 members are absent.
Okay. Representative Evangelos, can you let us know what your position is? I think we know, but you can.
Turn my microphone on. It's ought not to pass.
Okay. And Representative Babbage?
Yes, mine is ought to pass as amended. My report is to accommodate the ability of the victim or alleged victim to not have to physically confront the defendant. However, it shouldn't be made easy. So I have the amendment is number 1, may in the first line, which is part of the majority now. Number 2, in a criminal proceeding, I want it to be part of the trial in a live criminal proceeding. 3 would be the same amendment that has been made in the majority report about a defendant being able to be to see the child testify and consult with their attorney. And the 4th part is what I had mentioned initially. And although I love child advocacy centers, I don't think it's necessary to house a judicial activity there. And so I don't think court officers need to be ogres, but I would want it to happen in a court with a court officer and with the proceeding being recorded, including the activity of whoever else might be in the room with the child during testimony. Thank you.
If I may, could I just clarify what you mean by court officer? Do you mean a judicial marshal? Because attorneys are sometimes referred to as officers of the court.
Thank you. Yes, I'm thinking of a nonpartisan person in the trial that would be an employee of the court. You know, I don't know what would be the appropriate person to put there, and it needn't be one. If I were presiding over this, I would, or if I were the judge, I would say no eye contact during testimony, and that they merely be there as a resource for the child if they needed water or if, you know, but we're not in communication with the child during testimony. And the only reason I'm asking that it be a court officer is to assure that it's not a child advocacy person or a anybody that may seem to be it's really got to be a nice person. Depending on the age of the child, you want it to be
A nice court officer.
But I don't want that in the law. I just want it to be somebody that's impartial, an impartial person.
Representative Moriarty, I think you had your hand up first.
Yep, I've got a suggestion. Use the term court security officer.
Okay.
We all know who they are.
Okay. Representative McCray.
Could I register my vote? Is it too late? Is it ought to pass as amended? I assume there's an amended.
Mhm.
Thank you.
Thank you. Supi, you're on mute.
We have two ought to pass as amended.
I think Representative McCray, did you intend to vote with the motion?
Yes.
Yes.
Thank you very much.
Thanks. Okay. All right, Peggy, you have what you need on Representative.
I think I do. Thank you.
Okay.
Thank you very much.
Representative Reckett. Okay. Okay. So with that, we finished our work on 1612, and I'm going to thank the sponsor, Representative McDonald, for being with us and send her back through the wormhole.
Thank you, committee.
Okay. The next item on our agenda is LD 1630. And I see the sponsor is with us, so I'll bring him in. And I think it may make sense for him to speak before we hear from Peggy on this one. It might save us some time.
Sure.
Okay, Representative Pluker, welcome to the Judiciary Committee. Please go ahead.
Thank you, Madam Chair. There's a number of amendments that I'd like to talk about. I spoke to Senator Carney a little bit about this last night on the phone, and so it's a matter of bringing together a couple different points of view. So I've been working with the Attorney General's office as well as the Judiciary to try to deal with some of their worries about the bill. And then I also had heard from the committee members around potential worries around the 14th Amendment potential issues. So I can kind of launch right into potential amendment changes to the bill or talk about the 14th Amendment, however the committee would prefer me to start.
Why don't you tell us about sort of what you intend for the bill to be amended to do?
Great. So for those who have the bill in front of them, the Attorney General would like it to be clear on page 2, line 36, that it is the Attorney General or designee who would participate in the commission, not just an employee of the Attorney General's office. There was also some worries around gathering the data and who has the data and who and so that it's not overly burdensome. A lot of the amendments that we're going to be making are making it clear that the bill to not make it too burdensome upon the Attorney General's office or the judiciary, the administrators of the judiciary. So on page 3, line 24, we're just going to eliminate the requirement to gather that data for the commission. On page 4, line 1, the courts are worried about, and I don't know if Ms. Finn is in the attendees room, but she might be good to bring in. She could kind of talk about their perspective, but particularly looking at determining the income levels of the defendants. And it's a little bit of a complicated scheme as it currently exists within the bill. And so we want to make it clear that put that onto the commission, that part of their work would be determining a method of determining the income of the defendant in a way that is not overly burdensome. And some of this work is already happening with Indigent Legal Services, though, as your committee is clearly aware, Indigent Legal Services doesn't exist in all places. So trying to figure out a way that would work that would not be overly burdensome. So on page 4, line 1, trying to make it clear that part of the work of the commission is to determine a less burdensome method of doing so. On page 5, anybody can interrupt me with questions as soon as they like. Page 5, line 11, the Attorney General wanted to make it clear that they don't keep the arrest data, but it might be easier for the judicial branch to provide the arrest data. And then making it clear at the end of the bill, page 5, line 33, that the commission shall report to the committee if there is a less burdensome method for determining net income from individuals for use of the courts of levying fines. And then going over to the some of the suggested amendments coming from the judicial branch. Let's see. Also making it clear about the member of the commission would be a judicial branch appointee appointed by the Chief Justice, not the governor. That's on page 2, line 32. And with respect to the judicial branch providing arrest information, they're going to check in on that. And then subsection 1784, they just wanted to remove that completely from the bill, because the way the function of this bill is formed is that we're going to put the commission together. They're going to study this issue. They're going to create offense units. And then we're going to eventually use those offense units in the calculation of a proportional fine, a fine that is proportional to their income. So we're just going to remove 1784 at this point, and then that can be re-added in 2022 when this committee sees the bill again, or a subsequent version of the bill coming from the report from the commission.
Okay. So Representative Pluger, those went by really quickly. I think Peggy, she's masterful, so I'm sure she got them all, but I'm wondering if you have them in writing and could forward them to Peggy so that she has what you were reading from.
Yep, I have them in 2 different places, and I'll put them together and send them right to her.
Okay.
Is that now or once the session is over?
No, you can do it after we finish talking with you. You don't have to multitask at this moment, but thank you for doing that, because I think Peggy was furiously writing and I was trying to scroll up and down to follow what you were doing in the text of the bill. Representative Moriarty, go ahead.
Thank you, Madam Chair. Representative Pluker, is this now a resolve instead of a bill?
Yeah, I mean, it's up to the committee if you prefer to make it a resolve, but instead of a bill. But it's forming this commission, so this commission can essentially do its work and study and report a bill back out to your committee in 2022.
Okay, my opinion is, based upon all of the amendments you just offered, which are difficult to absorb and integrate into the rest of the text and come up with full understanding, is that this ought to be a pure resolve and direct the Proportional Fine Commission to report back by December 1st or 15th and give authority to judiciary to report out a bill. I don't think this should be that we should vote on a bill.
Yes, I think that would work just fine. The real statutory changes that are going to come out of the work of this commission will be something that you'll be looking at in the form of a bill in 2022.
Right, that's what I'm thinking. Yeah.
Peggy, can you weigh in on that as a procedural matter?
So you can do that. You can, change a bill into a resolve. If you're expecting the Proportional Fine Commission to be a long-term entity, though, it's better to do it as a bill and put it in statute. If you're expecting it to just act as a study commission at this level and put together all those recommendations that will then be enacted into law later, then a resolve would work for that. A resolve would be better for that, especially if you think that the commission is going to change once all the preliminary work is going to be done. So however you want to go forward, I was kind of interpreting this as you're going to lay the framework for the commission into the statute, and then their actual work on how to determine what's an appropriate way to establish fines, or the proportional fines, would come later. But you'd still have that framework in the statute of this entity that is ongoing. However the committee wants to go forward with it, we can make it work.
Representative Moriarty, and we are going to hear from Julie Finn as well. So just Go ahead, Representative Moriarty.
Okay, thanks, Madam Chair. My intent is not to create a permanent commission, but rather to create a commission as a sort of a one-time study panel to report back by a defined date, and then they're done. My preference would be to give them some relatively broad and generic language or instructions, and not really adopt anything else at this stage. Thank you.
Representative Pluker, go ahead.
Thank you, Madam Chair. Grand majority of this work is by the commission is done up front. There may be some reason for the commission to continue to exist. So as new crimes are created, and they need a proportional fund, they need a offense unit assigned to them. That work could either be done by the legislature directly in the creation of the crime itself, or if we wanted to continue the existence of the commission so that they would have that work and do that work, that might work as well. Also, in conversation with the judicial branch, they were talking about the magnitude of the work in terms of going through these 1,700 different crimes, which are not just in the criminal justice statutes, but also in IF&W and motor vehicles, and that they may very well require more than just the 6 to 7 months they were laying out for them.
Mm-hmm. Okay, Representative Moriarty, go ahead.
Thank you, Madam Chair. Representative Pluker, I think that one of the recommendations of this commission could be whether or not they ought to continue as a permanent standing body.
And I agree. Thank you.
Okay. So we are going to hear from Ms. Finn as well. So I'm going to bring her in. Welcome, Ms. Finn. And I understand you wanted to give the committee some additional information about the judicial branch's response to this bill.
Yes, just a little bit. Thank you very much for allowing me to come over and say a few words. And thank you very much to Representative Pluker, who did reach out to us, and we had a really good conversation about this bill earlier this week, and he has reflected all of our concerns in his comments to you. But just a couple things to emphasize. The reassessment of indigent status by a judge, and that's in section 1784, which we had asked to be removed from the bill. That would be very burdensome. I mentioned that in my testimony. It might actually create the need for another hearing. So that that concern was certainly heard and addressed. In terms of data collection, there's some very specific language in the bill about that, about what should be collected. And he mentioned the Attorney General suggested that we could provide the arrest and summons data, and maybe we can. I just want to say we will be a very good partner in terms of data. We will provide whatever we are able to provide, and we will have it in a format that's very easy to absorb and to look at. The detail that's in the bill, I think we'd prefer to see more general language, because some of those detailed items we could provide and some we could not. So we just need to have a conversation about what we can and cannot do in terms of data, but we'd be very happy to provide whatever is possible for us to provide and be a good partner and a member of this commission. A couple things I also just wanted to add, and we did bring up some of the issues of the huge number of offenses when we spoke to Representative Pluker, but I do believe the bill is limited to Title 17 or Title 17A. And I don't know if that was the intent or not, but there are lots and lots of offenses in other titles of law. So I don't know what the intent was there. So that's really just a question. And then also, I think Representative Pluker had mentioned to me that he thought that this bill would go to criminal justice, and the report out for legislation in the next session that section, it's the very end, section 4 does say, mention criminal justice and public safety as being the committee that would report out a bill. So you might want to change that. So that's all I have to say. And thank you very, very much for allowing me to say a few words.
Kristen, can I ask if you have a thought on whether this commission should be established in statute or whether it should be a resolve that establishes sort of a temporary commission that then dissolves after its work is complete?
You know, I don't have a strong feeling about that. I think having a commission, you know, really dive deeply into these issues and figure out how this could be done, what resources it would entail, you know, look at all the offenses, of which there are many, should certainly be done up front. I don't know. I can't say whether the commission should continue long term. I think that's maybe too soon to tell, but I just don't know the answer to that.
Okay. And then on the timeframes, Representative Pluker flagged that the timeframes may not be feasible. Do you have, pardon me, suggestion for the committee as to the timeline? I apologize.
So are you specifically referring to January 1, 2022 as the report out date? Well, the more time, the better. You know, at the judicial branch, we have so much going on in terms of, you know, implementing e-filing, and this is all involves our tech staff, who would also be folks who would be involved in compiling some of this data. You know, we have the e-filing project, and you know, and I will mention again, the pandemic has put us in not a great place, and we have an awful lot of work to do to catch up. So the more time, the better is really all I can say about that. I know you're limited by your session and how much you can get done in one session, but more time would certainly be appreciated.
Okay. Thank you very much. Are there additional questions for Ms. Finn? All right, I don't see any. So I'm going to thank you for joining us. I'm going to send you back into the attendee list.
Thank you very
much. Okay, so discussion of the committee. Representative Evangelos.
So given, Senator, given my understanding that this is going to be referred for some further work on a study and then coming back for a bill, is that my correct understanding?
Yes, I think that's the idea. I think the question is whether it's a study or just the commission is established and then their first task is to report back to us a bill.
So, you know, any reservations, you know, that I have can be handled in that process then. So I'm willing to move on to pass as amended.
As amended. And I guess I'm looking for some guidance from the committee on the timeline. I think our options are somewhat limited. I think one option is January 1st, 2022, roughly, or February 1st, 2022. But another option would be to report back to the 131st, the first session of the 131st legislature. It seems like a long way away, but it isn't, sadly.
I like January 1st, and I'll include that in my motion.
January 1st, 2022.
Correct. Yeah, it gives them 6 months. Thanks.
Okay. Is there any further discussion on the timeline? All right, seeing none. Is there a second for Representative Evangelos' motion? Seconded by Representative Babbage. And just so I'm clear, Representative Evangelos, you would keep it as a statute establishing the commission rather than transforming it into a resolve. Is that right?
Correct. I believe that was, I heard some flexibility on the part of the sponsor, but I think that's correct.
Okay. Okay, I can live with that.
I'm willing to entertain any pros or cons regarding that.
Or Representative Moriarty?
If this is to be a bill, I guess my vote will be no on the motion. And just for discussion purposes, what I would offer would be ought to pass as amended, with the amendment being that the bill is transformed into a resolve, and the resolve would incorporate the language of section 1783 on page 2 with subparagraph number 1 dealing with membership. And I think that gives broad general instructions to the commission, tells us who's going to be on it, but we don't need to decide if it's going to be permanent. We don't need to decide on staggered terms. We don't need to deal with the merits because we're turning it over to them to get into this and report back to us really in a pretty accelerated time frame.
Okay.
That's what I.
Representative Cardone.
I would agree with Representative Moriarty on the issue of it being a resolve rather than a bill. I hesitate to make a permanent commission through this bill. If through this study, they want to recommend a permanent commission, that makes more sense to me. But for now, I think it should remain as a resolve. Or should be transformed to resolve, I'm sorry.
Representative Evangelos.
Before I withdraw my motion, I'd like to hear just very briefly from the bill sponsor to make sure that that fits his objectives.
Representative Pluker.
Thank you very much. I'm okay with the resolve. I wanted to be clear that were you discussing including subsection 1785 and 1786, which I think might be important as well, just in terms of staffing the commission, because going through all these statutes and doing this work by volunteers will be extremely difficult. So making that clear, I think, and then also giving the commission some rulemaking authority to collect the data they need in pursuing their objectives and accomplishing what they need to accomplish. So I think including subsection 1783, excluding 1784, but including 1785 and 1786 would make sense, as well as that last chapter there, section 4, proportional fine commission review of fines and crimes.
So Representative Pluker, I'm sorry to interrupt. I didn't mean to do that, but I don't believe that a study commission can make rules. So it also, the timeline just doesn't make sense for rulemaking, right? The report back would happen before the APA deadlines could possibly have been met for rulemaking. So I think we can have one or the other. We can have this formal commission process with established rulemaking, or we can have a quick turnaround, but we can't have both.
Thank you. That's a very good point. Yep. So then just the staffing would be significant then.
Okay. I think that can be included in a resolve. Peggy, can you nod as I think that's allowed. Okay. Representative Evangelos.
I'll defer to Representative Moriarty.
Representative Moriarty.
Yes. Fully agree on the rulemaking point. 1786 can't be part of the resolve. 1785, as we just said, we got 6-7 months here. I don't know that this commission can really delve into the data on crimes and fines. I see them primarily as dealing with the concept, the principle, the legality, the constitutionality, the workability, and not getting into the weeds. So I don't, and staffing will carry a price tag with it, which could, shoot down the whole project.
Okay.
So I guess I would.
Representative Pluker,
would include it.
Representative Pluker, can you speak to whether you envision that the commission is going to be establishing the fines, or whether they're going to be establishing the parameters for the concepts with a bit more input going forward? So more like a stakeholder process and then a subsequent bill.
From speaking to the judicial branch as well as the Attorney General's branch, and I believe also from this committee, there seems to be wide agreement that this is a process that there needs to be a general overview look at our statute and how to make to explain what Ms. Finn said to me the other day, which is that we tend to look at one crime and look at the fine in that one crime without looking to it in the broad. And this work of a large scale look at our statute and how fines are being used within 17A is important and significant. So I think that creating a commission to just ask whether or not this is important and significant, I think that's been established, especially if this committee supports that work. I think the important work here is to actually create a new system that we could use. And that's what the intent of this bill is, to create the new system of these offense units and the proportional fines. So I would see that as being its primary work, rather than just wondering whether or not we should eliminate mandatory minimum fines.
Representative Evangelos.
So we're getting into the weeds now. Representative Moriarty, I am willing to withdraw my motion if you and support the resolve idea, as long as you can come to terms with the needs of the bill's sponsor. So if you're willing to include his concerns into the resolve language, then I'll withdraw my motion and support yours. But can you two talk for a second and make sure you're on the same?
We can. I deeply appreciate your comment. I do have a question for the sponsor. When and where has it been determined that there should be proportional fines? I thought that was still an open issue.
Yes, it certainly is. I think that your committee is determining that with the vote today on this bill.
Well, no, I think not if we set up a study commission. We're not.
That's true. I guess that is exactly what we're deciding right now. If you decide to just set up a study commission, then you're studying the issue. And if you decide to move the bill as originally written, then it would be the committee's agreement that we need to move forward with creating proportional fines.
Okay, then I'll be specific with my proposed motion, and that would be to transform the bill into a resolve to create the proportional fine commission for the purposes of studying and implementing proportional fines throughout the state, period. The commission shall consist of the following members, and then just track the members in section 1783. And then finish up with the report date. And Representative Pluker, Julie Finn was correct in pointing out that the recipient of the report is not this committee, but criminal justice. Where do you want to be?
And I included that comment in my testimony hearing, but I did not include it in today's testimony. I apologize. I said in that time, I said, if the Judiciary Committee would prefer to continue the work, then I suggest that you state Judiciary Committee. Yeah.
And I think having started it, I think we should. So the final part of my proposed motion would be that the committee report back to Judiciary no later than January 1, 2022.
Can I just ask, I think you used the word to study and implement. And I feel like that might go too far. I don't know that that's what you meant.
To study and consider the implementation. How does that sound?
That sounds much better.
Okay.
Or recommends a process for implementation or something like that. I think is more what you had in mind, Representative Moriarty.
Yes, it is. Yes.
Okay. Representative Evangelos.
Representative Pluker, are you on board with Representative Moriarty's suggestions?
Yes, I mean, if that's the direction the committee wants to go, I'm ready to work with the committee in 2022 to move forward in whatever the commission decides.
Well, I preferred the previous motion, but we want to get close to a unanimous report as possible. And it looked like divisions were erupting. So,
but yes,
I want to know that if what Representative Moriarty is proposing meets your minimum standards, because if it doesn't, I'll stick to my original motion. I want to know what your wishes are, sir.
Thank you, Representative Evangelist. I'm ready to. I think this is the first step forward in a longer term project that I look forward to being part of, and I appreciate Representative Moriarty's motion.
Okay, Madam Chair, I'll withdraw my motion.
Okay. Is there a new motion, Representative Moriarty?
Yes, shall I restate it or?
No, I think Peggy's got it. You can just move on to pass as amended.
I move off to pass as amended. Yes.
Okay, great. Is there a second? Seconded by Representative Evangelos. Great. Is there further discussion on the bill? Okay, I need to see 7 people. 1, 2, 3, 4, 5, 6, 7. Perfect. Thank you, Representative Reckett and Supi. We're ready for the vote.
Thank you, Madam Chair. Senator Carney. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Kine.
Sorry about that.
Representative Harnett. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative McCright. Representative Cardone.
Yes.
Representative Cardone votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Poirier. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell. I'll recall the absentees. Senator Carney. Senator Carney is absent. Senator Kime. Senator Kime is absent. Representative Harnett. Representative Harnett is absent. Representative Hagan. Representative Hagan is absent. Representative Poirier. Representative Poirier is absent. Representative Newell. Representative Newell is absent. Madam Chair, I have 8 members voting in the affirmative. I apologize. I'm going to go backwards. Thank you, Representative McCright. Representative McCright.
And the motion is ought to pass as amended?
That is correct.
Yes, thank you.
Representative McCright votes yes. And again, my apologies.
All right.
And the vote is?
I'm sorry. I've counted twice and I don't know why I can't put them. Madam Chair, 8 members voted in the affirmative, 0 in the negative, and 6 members are absent.
Okay. Thank you very much. Representative Babbage wanted to return to 1612 briefly to update his amendment for his report.
Thank you to the
Representative Babbage.
I didn't know if this is necessary, but I did want to clarify for Peggy that my amendment in the neutral court environment, I suggest, I appreciated the suggestion, but I'm not going to go with an armed officer. I'm going to go with an impartial court officer to be designated. Thank you.
Okay. Thanks, Representative Babbage. So the next bill that we're going to move on to, we're actually going to open a work session on 2 bills, which are LD 1438 and LD 1529, which are 2 related constitutional amendments related to privacy. I'll bring the sponsors of each in now. Good morning, Representative O'Neill.
Morning.
And good morning, Representative Facto. All
Good
right.
morning, Chair.
Good morning. Okay, so I think I'm gonna start by asking Representative O'Neill to let us know where she stands on her proposal.
Thank you, Senator. So good morning. And just as an update, we had talked about this a bit at the public hearing, but as soon as Representative Facto and I realized that we both had constitutional amendments that concern privacy, we decided that we wanted to coordinate on it after talking and seeing that we had similar values and intentions. So we've done a lot of work before the public hearing, after the public hearing, to work on it together because we think it's a really good opportunity for bipartisan legislation and really in keeping with Maine values. So to go through a little bit of background on what we've been doing between the public hearing and now, Representative Facto and I have met with different stakeholders, and those include Major Scott from the Maine State Police, the ACLU, defense attorneys, and we've been really grateful for everybody's time and attention to this. People have been really willing to make themselves available and talk things through. So something that I also want to let you know that I had the chance to in my testimony, you probably don't remember because you have the busiest committee of all, but I provided some information about other states that had these kinds of amendments. And between the public hearing and now, I had the chance to meet with folks from Michigan who had a similar amendment that happened to go through their House and Senate unanimously, and voters passed it, I think, with 89% of the vote in 2020. So I met with them to get some information about their process. And then we also have developed language, which I have sent to your analyst, along with some further information about 3 of the most recent privacy amendments, which were New Hampshire 18, the Michigan one that I mentioned from last November, and one from Missouri in 2014. So all those resources are there for the committee. And we've also been working language with Senator Donna Bailey, Representative Billy Bob Buckingham, faculty from UMaine, the School of Law, and different privacy practitioners who have been willing to sit down and be a part of this. And in agreement with stakeholders, we have reached out to the committee ahead of time to request a carryover and to merge our bills together. The stakeholders have really been great partners, and we think that with a little bit longer, we can really tease these issues out and come to a place where we agree.
Okay, thank you, Representative O'Neill, for that overview of where we are. So the sponsor of LD 1529 is requesting a carryover, and if I understand it, the agreement of the 2 sponsors is that LD 1438 could be voted on not to pass, and we would go forward with a single vehicle into the carryover. But I want to check with Representative Facto and make sure that that is his understanding as well. So Representative Facto, welcome, and go ahead.
Thank you, Madam Chair. I'll be brief. Consensus, especially when it comes to constitutional amendments, is of the utmost importance. I agree with Representative O'Neill that we need 1 vehicle, and we've chosen her vehicle, and there will be consensus in the second regular session as we continue to work through this, and I look forward to it. Thank you.
Great. Thank you very much. And it's nice to have bipartisanship in the Judiciary Committee. It's always a good day. So thank you for that. Representative Evangelos, go ahead.
Hi, Representative Facto. I just wanted to thank you for your compelling testimony. I've researched and read a lot about these subjects, and you nailed it. So I wanted to recognize your contribution. Thank you very much.
Thank you, Representative.
Okay. So is there further discussion of the two bills? All right, so seeing none, I would entertain a motion first on LD 1438, which someone needs to make. Representative Sheehan?
Thanks, Madam Chair. In light of the sponsor's intentions, I move ought not to pass on LD 1438.
Thank you. Is there a second? Seconded by Representative Cardone. And I see 1, 2, 3, 4, 5, 6, 7 members of the committee. Great, so we can take a vote. Is there any further discussion? Seeing none, we'll have Supi call the roll.
Thank you, Madam Chair. Senator Carney. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Kime. Representative Harnett. Representative Babbage.
Sorry. Yes.
Representative Babbage votes yes. Representative McCright.
Yes.
Representative McCright votes yes. Representative Cardone.
Yes.
Representative Cardone votes yes. Representative Galgay-Reckitt. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Poirier. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell. I'll recall the absentees. Senator Carney. Senator Carney is absent. Senator Kime. Senator Kime is absent. Representative Harnett. Representative Harnett is absent. Representative Galgay-Reckitt.
Yes.
Representative Galgay-Reckitt votes yes. Representative Hagan. Representative Hagan is absent. Representative Poirier. Representative Poirier is absent. Representative Newell. Representative Newell is absent. Madam Chair, I have 8 members voting in the affirmative, 0 in the negative, and 6 members are absent.
Thank you. Okay, and next we'll move on to a motion on LD 1529. And my understanding is the tabling motion is in order for us to consider this with the rest of the carryovers in the committee. Representative Evangelos.
Move to table.
Is there a second? Representative Sheehan? Okay. And I don't know if we roll call table motions in this committee or if we just use electronic hands.
This is a non-controversial one. Let's try the hands.
Okay.
Madam Chair?
Yes.
We don't use the electronic hands because apparently it doesn't show on Facebook. So we have, you need to raise your actual hand.
Your actual hands. Okay, we'll be raising our actual hands for the tabling motion. So please raise your actual hand if you agree to table the bill. We do need, well, it's not a roll call, so I'm not sure if we need a quorum, but Representative Cardone, did you have your hand up?
Okay, now I have 7.
Now we have enough. Okay, great, thank you.
Thank you.
Okay. So my thanks to both sponsors and thank you for being here. I'm going to send you back through the attendee link.
Thank you.
All right, we have just one bill left on our Representative Evangelos. Go ahead.
Senator Sanborn, I have to leave and it's going to follow up your quorum. I'm sorry.
Okay, I think it's okay. I think Representative Reckitt is available enough so that we should be okay. And I think we actually probably won't vote on the substance of the next bill. So
thank you very much. And thank you. You did a good job today. Thank you very much.
Thank you. Okay. So the last bill on our list is LD 982. I was a little bit over ambitious in thinking we could get through the list in an hour, but how about 2 hours? So the last bill is, like I said, LD 982, an act to protect against discrimination by public entities, particularly in correctional facilities and jails. Peggy, can you give us an update?
Yes and no, yes. So you tabled this once before because we wanted to work on some language. The bill is drafted, amends the public accommodations subchapter of the Human Rights Act. And that's not really where this kind of expansion should go. So we're exploring how to write it into its own separate subchapter that would apply to public entities. But it's actually fairly more complicated than just writing public entities may not discriminate. And we still need to identify what it applies, what public entities would apply to, employment, housing, education, amend the policy statement, pull in whatever definitions are necessary, and then actually set what those standards are about. It is unlawful discrimination for a public entity to do what? To discriminate on what basis or in what activities or conduct or and a question about whether we apply the construction standards that are existing in the current law with regard to public accommodations, and update all the other provisions about the commission's activities and actions and lawsuits. So we haven't really been able to sit down and work through all that. We've just kind of raised the questions without figuring out what answers are to put before you for the committee then to consider whether to go forward.
Okay, so it sounds like this is work that needs to be done in the interim when you aren't trying to prepare 72 bill analyses for us every single night. So we would be looking to carry this bill over. My understanding in talking with the actual chairs of the committee is that we do have the capacity to do that. I apologize for the barking dog. So I think the intention here is that we would table in order to vote on it as a carryover when we vote on all the carryovers. Is there any further discussion on the bill? All right, seeing none, I would entertain a motion. Representative Babbage.
I move the table, Madam Chair.
Okay, is there a second? Seconded by Representative Sheehan. And let's see, Representative Moriarty, are you there?
I'm here.
Okay, can you turn on your video?
I will.
Wonderful. Okay, so if you would raise your hand in your window so that we can indicate the favorable vote for the tabling motion.
The motion to table?
The motion is to table, Representative Moriarty.
6, 7.
So it is 7 of us to table. And I think with that, we have completed my dog's ability to survive without my attention and our work for today in the Judiciary Committee. Does anyone have any further comments? Oh, I just saw that the sponsor joined us, but we had already tabled. Sorry. So I think we'll just let that go and encourage the sponsor to work with Peggy over the interim, and I trust that that'll happen and we'll have a good bill to work on in the next session. All right, is there any further announcements or are we ready to adjourn? Musubi.
Yeah, just to remind members at 10 a.m. on Tuesday, you have a confirmation for the Chief Justice of the Maine Supreme Judicial Court, which is fairly big. And I will be sending out your links later today because there is no Monday. We're not in on Monday because of the holiday.
And if we have time after the confirmation, we'll probably be working Tuesday, and we have been approved to work on Friday. So we'll be dealing with the bills that are tabled, just a few of them, and then all the carryovers somewhere in there, and all the amendment reviews. So I'm gonna try to start figuring out the best way to organize those. Some of them will definitely need action by you. So we'll take the weekend off. You'll be very busy next week.
Okay. Representative Babbage, you had your hand up.
Oh, oh, no.
Not
it's-
anymore, but you did.
Oh,
It
okay.
was the first
I did
one.
want to thank you and well done, Madam Chair. Thank you very much.
Okay. All right. Well, so with that, I think we will adjourn. All right. Thanks, everyone.
Thank you,
Hey,
everyone.
Thank you.
take care.
Nice weekend.
Have a good weekend.